story. A father is suing the Museum of Ice Cream over one of its most visited attractions. It's called the Sprinkle Pool.
It is basically a giant ball pit filled with plastic sprinkles. The man claims he broke his ankle after jumping into it during a visit to the museum in New York City back in 2023. He says the museum failed to adequately warn people that it's unsafe to do so. And he says it even encourages people to jump in. The museum, for its part, has not yet commented on that lawsuit.
Joining us now is lawyer and author Amy Feldman. So, Amy, we were so curious about the legalities of this. What specifically is this man alleging in his lawsuit?
It's negligence. His claim is that there is, on the website, it says, come on, join us, jump in. And he took them literally, jumped into this pool and broke his foot in a way that caused him to need surgery, and that it was a very dangerous place.
Amy, it's not lost on me that many places, whether it's a place like this, the museum, an amusement park, an interactive pop-up, they tend to have you sign a waiver. Whether or not people read that is a different question.
Right.
But I wonder, what does this mean for folks who are attending an event, an experience like this, and maybe see that kind of paper?
So you're absolutely right. And in fact, the Museum of Ice Cream's waiver that they make you sign is in pink ink. In case you were wondering, is this an ice cream place or not?
Oh,
you know?
wow.
Yeah, and it's hard to read, but that doesn't mean that you shouldn't read these things. But what I will say, and he signed it, by the way, and his case admits that, and then says, oh, and by the way, as the museum well knows, under the New York General Obligations Law, all of those waivers are illegal. They can't be enforced in New York. In New York. Because if you are a place of amusement that accepts money as admission to let people in, if you're giving them these waivers, they're unenforceable. You can't just waive your liability.
You can't be exempt from a lawsuit just because somebody signed that. Okay, more broadly for the rest of the country, not just New York.
Yeah.
If we sign these things like at the trampoline park or the amusement park, are we really...
So in a lot of
still to sue?
Yeah, I mean, in a lot of states, you are bound by those waivers. So it would be a wrong conclusion to say, well, I guess if they're unenforceable, they're unenforceable everywhere. You need to know where you are, and you need the state law to support you on that. That said, I think the bigger lesson for people is if you see that this is a wading pool, that small children are not even up to their knees on it, don't jump in, right? Like, let's use some common sense. You want to avoid a lawsuit, avoid these silly mistakes that people make.
And we mentioned the Museum of Ice Cream, at least thus far, has not commented. But where does this case go from here, Amy?
Yeah, well, I think that it teaches business. So they're going to argue, now that this waiver is unenforceable, they're going to have to fight it. However, the way they're going to fight it is the way that all companies fight it, which is to say, we're not really negligent. He used bad judgment, and he was not being reasonable when he did it. That's going to be their best argument. And I think it's a lesson to everybody, especially Willy Wonka, you know, which is just make sure that Augustus Gloop doesn't get himself lawyered up.
No, really interesting analysis, especially as many people are going to be jumping into things this summer. Amy Feldman, thank you.
Brooke Shields has spent decades in the spotlight. Her career began